Coming up next on Arizona Horizon, it's our annual U.S. Supreme Court review. We'll take a look at some of the major decisions from this year's session and discuss other aspects of the High Court's term. It's our Supreme Court review, and it's next on Arizona Horizon.
Arizona Horizon is made possible by contributions from the Friends of Arizona PBS, members of your public television station.
Good evening and welcome to Arizona Horizon. I'm Ted Simons. Tonight is our annual Supreme Court review. Each year we look at some of the bigger cases decided by the High Court and discuss what those decisions say about the court and the country. Our guest tonight, Attorney Stephen Montoya, a partner at Montoya, Lucero, and Pastor. Stephen, good to have you here. Thanks for joining us. I'm looking forward to this. I always like these shows. All right, let's start. Before we get to individual cases, the session as a whole seemed pretty momentous, was it?
It was a blockbuster, and quite intentionally. I think the conservative court majority wants to gain as many mileage and create as many precedents as it possibly can when it has the votes, because as you know, votes can go up and votes can go down. No member of the court is immortal, and ultimately they will be replaced. By whom, no one knows.
Yes, but it would seem though that they, in other words, strike while the iron's hot is what they're doing.
Correct.
Yeah. All right, let's get to individual cases here. And the biggie, as far as my impression would be, is birthright citizenship. The executive order, President Trump's executive order, literally an executive order on a constitutional issue. And the court basically...
Talk about a separation of powers violation.
Yeah, and the court said, I don't think so.
True. The court stayed true to the express language of the 14th Amendment, the first sentence of the 14th Amendment, that everyone born in the United States, subject to the jurisdiction of the United States, was a citizen. Now, the issue of where someone was born is simple. The issue of whether or not you're subject to the jurisdiction of the United States is also simple. Any college student or first-year law student knows that anyone who is subject to the judicial and police power of the state is subject to the jurisdiction of the United States. Everyone here illegally is subject to the jurisdiction of the United States. They can be arrested and be deported. They can be granted asylum, etc. So it was an easy case. However, it wasn't an easy decision for the court to render. As you understand, the constitutional issue was decided by the court 5-4, much to everyone's surprise, including my own.
Because it seems so clear-cut.
Because it seems so clear-cut. What the dissent said is, even though the 14th Amendment doesn't mention domicile or allegiance, that little babies who have no domicile, in order to have a domicile, you have to have an intent to maintain your residence in a particular jurisdiction. All the little babies that I've ever conversed with really didn't know where they were going to live, nor did they have allegiance to the United States. The concepts of domicile and allegiance are really parental, and therefore go to like their parentage, not their birthplace. That's why those arguments, in my view, were absurd.
The other argument, Trump administration Solicitor General, the idea being that, yes, it's clear. It's right there in the 14th Amendment, clear as a bell, but it wasn't intended to be for anyone other than enslaved Black Americans and their descendants.
That's not true. Read the language of the amendment. It says all people. Moreover, if you look, if we're interested in the original intent, I happen to be, this is my kind of profession and hobby, studying the history of this. The congressional debates of the framers of the 14th Amendment, this issue was brought up, and I'll tell you what, they were targeting two groups with suspicion. The Roma, whom they referred to as the Gypsies, and the Chinese. And someone said, well, under this amendment, these Gypsies and the Chinese, their children are going to be citizens automatically. And guess what? The proponents of the amendment said, yeah, that's true. That's the way it goes. That's true under the English common law. That was also true under English statutory law.
And it would be true, the Trump administration's argument would be true if they had said that in the amendment. If the clause had said African American, Black American, enslaved people. It doesn't say that.
No, and I actually, a lot of African American children's parents were here illegally because they had been smuggled into the country in the illegal slave trade illegally. Actually, a famous execution by Abraham Lincoln ordered an execution of a ship captain who was caught smuggling slaves illegally to the United States. And it was quite controversial. They asked that he be pardoned, and Lincoln said no, he was executed. He was a slave trader illegally.
Real quickly, the last point on this one is that Justice Kavanaugh, he ruled with the majority, but he wrote a dissenting opinion. So that's why it was a 5-4 and 6-3 there.
Correct.
Surprise you?
It did surprise me initially, but then Justice Kavanaugh, with all due respect, has a habit of doing stuff like that. I actually thought there was a possibility that the court might decide the case on statutory grounds. There's a very old doctrine, it's called constitutional avoidance. If you can decide it on statutory grounds, do that, not constitutional grounds. The court, I believe, chose not to do that because they wanted to end this controversy for the sake of the country once and for all.
Yeah. All right, let's move on now. Another that kind of got lost in the mist here, lost in the trampling dust. Tariffs. The court basically struck down Donald Trump, President Trump's tariffs. Were you surprised by that?
Well, yes and no. I wasn't surprised at all because the concept of the president being able to unilaterally control tariffs over every country in the world, and when you tax imports, you're taxing the American public too. That was a usurpation of Congress's power to tax, which is fundamental in the Constitution. So, you know, I agreed with the court, but the way the court is always ruling, they're always giving the president everything that he asks for virtually, and when they don't, it's almost a shock.
Well, and again, the idea that the president wanted to use the the Economic Powers Act, and it sounded like the court said, you can use that to regulate, you can't use that to tax.
They did say that you could use it to regulate, and the statute says you can use it to regulate if in fact there's an emergency, but taxing is something different. The court employed the major questions doctrine. A lot of liberals are against it. I actually, even though people think I'm a liberal, and in some ways I am, I actually think that's a good tool. You want to incentivize Congress to speak very clearly and explicitly.
Yeah. Case, Louisiana versus Calais. This deals with racial gerrymandering in Louisiana. This was a pretty big case.
It was a huge case, and it was a very unfortunate and huge usurpation of congressional power. Under the 15th Amendment and under the 14th Amendment, Congress is given the power to regulate voting and to also interpret the Constitution in reference to voting and in reference to enforcing the Equal Protection Clause. The Constitution itself says that. They did that by enacting the Voting Rights Act, then reenacting it 4 times under Republicans and Democrats, and the court actually struck down de facto Section 2 of the Voting Rights Act that had been expressly amended in a Republican Congress to prohibit any type of electoral change that disparately impacted minority voters. And the court basically struck that down and said, notwithstanding Section 2, you have to show discriminatory intent.
So the court said use of race violates Equal Protection Clause.
Absolutely, but here's the context in which they said it. See, a group of Louisiana voters who were opposed to a second majority minority district consisting of African Americans, they said, hey, you creating this second majority district full of African Americans, that's discriminatory. You did that just because they're black. And they took it all the way to the Supreme Court, and the court said, yeah, that's racial discrimination. That's racial gerrymandering. This racial remedy for disparate impact actually violates the Constitution in the eyes of this court.
So when Louisiana made this one district and tried to get as many African Americans into this one
packed it.
district, that was not racial gerrymandering?
Well, the court initially said, has always said that was racially gerrymandering. The court said that speaking through Chief Justice Roberts in a case called Allen versus Milligan in 2023 that affirmed the disparate impact standard of Section 2. But in the passage of 3 years, suddenly that wasn't right anymore. And you have Roberts joining Justice Alito in saying that creating that second minority-majority district was a racial gerrymander that violated the Equal Protection Clause and also violated the 15th Amendment.
Impact on voting rights in America.
Well, we've already seen it. Now it's okay to gerrymander across the board, but instead of saying, hey, we're doing this to get rid of blacks, all you do is say, we're doing this to get rid of Democrats. And under another Supreme Court case authored by none other than the Chief Justice, you can do that. Political gerrymandering is not problematic legally, and it's permissible. So now you just say, hey, we're trying to squeeze out the Democrats, and it's okay.
Yeah, it just can't be racial. It can be
Yes.
political, but not racial.
Correct.
All right, Trump v. Slaughter. This was just recently here where the president, again, presidential authority can just fire independent, quote, independent agency heads willy-nilly.
Yeah, that is a very important case. It shows the farce of originalism because the Chief Justice said, oh, the framers thought that the president should have removal power. But the case that they were relying on was decided in 1926, Myers versus the United States. And in that case, the court acknowledges this is not in the constitutional language. There is no trace of it in the ratifying conventions or the constitutional conventions. We're announcing this rule based upon the implicit power of the president as the executive. It's a prerogative power. But the framers of the Constitution had already rejected prerogative powers because those were associated with another George, not George Washington, but King George, and they were against that. That was part of the revolutionary motives that our founding generation had. So it was really ridiculous, but here's why that's a very dangerous case. And it's supposedly based upon the separation of powers. Oh, well, these independent agencies exercise executive power. Guess what? They also exercise legislative power. They make rules. They're rule-making bodies. They also adjudicate cases. They have judicial power. And this is not mentioned in the Constitution. The part of the Constitution, it's not mentioned in Article 2. The part of the Constitution that does mention it is Article 1 regarding Congress. The necessary property clause says, hey, Congress can create rules to govern the departments that Congress creates. And in the Myers case that I previously mentioned, Justice Holmes, he was a lightweight jurist. He dissented from the majority opinion, saying that the president had removal powers by saying, hey, listen, come on, Congress created this entity and can dissolve the entity. So if Congress also wants to say that we have a say in the removal powers of the people who run the entity, Congress has that right. That's what Justice Brandeis also concluded.
Yeah, but back to Article 2 here in presidential authority, I believe the majority opinion said, didn't use, these are my words, the old football analogy. If you have two starting quarterbacks, you don't have a starting quarterback. If you have more than one executive making these decisions regarding, firing and letting people go, hiring the whole 9 yards, you don't really have an executive.
And that's not true. First of all, there is an authority, and the authority is Congress. And Congress is the entity that passed the law, which was signed by every president Every time one of these independent agencies was created, Congress created it, and the pick was not vetoed by the president. So both branches of government validated it, and they're multi-member. They're governed by multi-membered commissioners who have staggered appointments. And they're designed that way to be independent, because not everything should be partisan. And this is why the Slaughter case has really unleashed a can of poisonous worms.
Real quickly, on that point, the president said this is Trump speaking, quote, greatest increase in presidential power in the last 100 years.
Yeah, because you know what the president is going to be able to do? Even though the statute says that it's a multi-member commission with staggered terms, and they have to be half Democrat or in half the other party, which is Republican. The president under Slaughter is now going to attempt to fire everyone and replace them with all one party, and thwart the will of Congress, because the president's supposed to execute congressional orders in the form of statutes, not stymie them or pervert them. And Congress has the right to do that.
All right, we got to keep moving here. We've got a couple of cases here. The first one involves temporary protective status for Haitians. You take this one because it's somewhat complicated, but the bottom line is that revocation of temporary protection status, sounds like the Supreme Court said, okay, fine.
That's exactly what the Supreme Court said, and I find that very disturbing, because the Haitians also filed an equal protection claim against kicking them out of the country and revoking their temporary protective status based upon the president's comments, which I'll quote. The president said the Haitians probably have AIDS. Haiti is a shithole country. Haitians are poisoning the blood of the country, and Haitian immigration is like a death wish for the country. Those are highly discriminatory terms. Under the Equal Protection Clause, that type of language has always been shown or has always been accepted to constitute discriminatory intent. The president cannot violate the Equal Protection Clause, but yet the majority of the court, through Justice Alito, said, hey, you can't take those seriously. There were other valid reasons to exclude the Haitians, so disregard and ignore the president's racist rhetoric and let the order stand. I think that was a grave violation of the Equal Protection Clause.
And there was another case here. This was, I believe, the Cook case. I'm not sure. No, that was previous with Slaughter. I forget the name of this. El Oturlado, that's the one. Regarding keeping asylum seekers physically out of the country. Why is that a big deal?
Well, it was a big deal because during World War II, a shipload full of European Jews tried to dock in the United States seeking asylum, and they were turned away, and they all ended up being murdered by the Nazis. And Congress took that very seriously, and that was one of the impetuses for temporary protective status. So when people show up, you listen to them, and if they have a valid asylum claim, you let them enter the country legally. To keep them out is to deny them asylum, and it's the Supreme Court's interpretation of the law really defeating the purpose of the law, because in order to decide whether someone's entitled to asylum, you must first hear them. And if you keep them out of the country and refuse to listen to them, you're never going to hear their pleas.
Are those things separate, keeping them out of the country and refusing to hear? Can you still hear from them even though they're not physically in the country?
Yes, you can. However, in the real world, they don't. They keep them out of the country physically, and they don't let them apply. And when they keep them out of the country, sometimes they're actually allowing them to be murdered by third parties that the United States does not control. That's why they're seeking asylum in the first place.
Both of these opinions somewhat expected?
I think they were expected, and that was a sad thing. because the court is a very politicized, ideological court, in my view,
Yeah.
and also in a lot of conservatives' view.
Last couple of cases here both deal with the same thing, and that is girls and women, transgender women and girls in sports. And this, that it doesn't impact a whole lot of folks, but boy, oh boy, does it generate a lot of conversation.
It does, and it's a tough case. Depending upon the age of the transgender person, the transgender girl, hormones do impact the body, and not every transgender person has been under hormone treatments that really prevent them from having male characteristics. So I think that transgender girls sometimes do have a competitive advantage. I don't think it makes a difference when you look at the totality of the sport. But the problem I have with these rulings is the court keeps on making exceptions, allowing discrimination against transgendered people. And the problem with that, Ted, is the purpose of the purpose of the 14th Amendment. When it was introduced into the Senate, the person who introduced it said this is to prevent hated castes. And I believe that transgender people are becoming a hated caste in America and being turned into second-class citizens. And I think that is another step in that wrong direction.
And the court says that it does not violate equal protection. The court also said it did not violate Title IX.
Yeah, because Title IX really was based upon biological gender. So I do acknowledge that was a tough case, but it should have been a tougher case than the court made it, because the court, every time the issue of the rights of transgender people come up, it seemed like the court is always ruling against them.
In the majority opinion, the hard reality of sports cannot be ignored. But the dissent was kind of interesting. I think it was Sotomayor. I'm not
It
sure.
was.
Was it? The court,
Joined by Kagan and Jackson.
The court thinks that there's an inherent advantage. The court has not seen enough evidence of that yet. Does that make sense to you?
Well, I understand what she means. However, I really have to say that I think the science does indicate that if someone in puberty isn't undergoing hormonal therapy to suppress testosterone, who is a transgender athlete, a transgender woman or girl athlete, they do have an advantage. Testosterone increases strength. It increases speed. Female athletes who are not transgender sometimes take it to enhance their performance.
That's the hard reality. That
it is the hard reality.
Yeah. Before we go, we got a few minutes here, so these are great cases, and there were more, but we just have kind of run out of time as far as the individual cases. But on the whole, you talk about striking while the iron is hot. That seems to be what the court is doing right now. Do we see anything on the immediate horizon of the court changing, of someone retiring, of someone just saying, I've had enough? I mean, what?
Well, there was a big rumor from National Public Radio saying that Alito was going to retire. I don't think that was a mistake that was, created out of thin air. I don't know what was going on with that. Alito is scheduled to release a book. He is scheduled to take a book tour during, the opening months of the Supreme Court. It looked as if he were getting ready to retire. So I think he might retire. I don't think Thomas is going anywhere. I think he wants to try to shoot for being the longest-serving justice, and he has a ways to go. So I don't really see a lot of changes in the court. It wouldn't surprise me if Alito did retire in time for Trump to nominate his replacement and the Senate to confirm his replacement.
Yeah, and that's kind of what I was getting at there.
Yeah.
Last question before you go. We've kind of heard a little bit about what's going to happen next session, and it sounds like Arizona is going to play a big part as far as election law is concerned. What can you tell us?
Well, this has been decided by the United States District Court, and the Ninth Circuit has decided it. You know, Arizona said that you have to show proof of citizenship in the form of a birth certificate or passport in order to vote. It was enjoined. The Ninth Circuit supported the injunction prohibiting it. Now the court has accepted cert on it, and it really has the votes to uphold that. I believe that would be invalid because showing proof of United States citizenship in a federal election is something that Congress governs, not the state. So I think if Congress wanted to do that, it would have the right to do that.
Right.
But I don't think Arizona has the right to unilaterally do that. And Arizona might have the right to do that in reference to state elections, but when it starts infringing upon federal elections, I think it goes too far and should lose. But I'm never surprised. I am surprised, but I shouldn't be surprised by what the court does.
Yeah, and we've been talking about that dual system here on Arizona Horizon for what seems like forever. Stephen Montoya, again, great conversation. Good to have you here. Thanks for all your insight on the recent session.
Thank you, sir.
And that is it for now. I'm Ted Simons. Thank you so much for joining us. You have a great evening.
Because kids will always be more curious, Arizona PBS